All right, Jello again. This is Ben Hitchcock Cross talking to you today. The headline here is we have the proof now. It's always in the team's chats, apparently. That's the new secret communications channel, the new text message, if you will, um, where the Matt White and Maria Seltzer, the two directors, discuss not only listening in on the hearing, not only their interference with the hearing, but Matt White makes a joke about his interference in the hearing. I'm not going to focus in on any particular story today. We're going to sort of retell the story from October 2nd and tell what we know today. I'm still sort of processing things. I expected to get this story out days, hours earlier, but every every little bit you have to go back to some more public records. You have to review all of them. You have to make some more public records requests. I mean, I've sent out at least 8 public records requests since this morning, so that's something. And it's what, one? All right. Um, yeah, we're gonna have to get into the public records responses, the whole thing. But this is we're starting to get a better picture of the whole story, and what happened here. So some people's uh, protection of a bully is other people's First Amendment violations. Let's keep that in mind for reference. Now, here's the first thing that in this story that everybody needs to keep in mind. Now, these are allegations, but nevertheless, some years ago at an ice fishing event, a Department of Corrections employee, I think, grabbed the breasts of another Department of Corrections employee. Now, significant. It doesn't wait, there's more. The Department of Corrections is alleged to not have taken sufficient action to prevent further harassment, and as a consequence, the employee felt she had no other choice but to resign. Why is that significant? It's of tremendous significance here because we also have a case in which the Department of Corrections is alleged to have discriminated against a warden on the basis of race. In that hearing, two things come to light. Number one, uh, the secretary of the Department of Corrections is literally involved in every single um, employment decision at the department. And two, Amy Petchacek was his former deputy secretary and is now the current secretary of the Department of Corrections. Now, for both of these people to get justice, one thing that was necessary is to have evidence about or from Amy Petchacek. There are other people, by the way, who had the same sort of problem. But this Joanna Stolar is the most significant. And the Department of Corrections, the Department of Workforce Development have gone, and the Department of Justice have bent over backwards to keep Amy Petchacek from testifying under oath, just telling the truth under oath. That's what this, in large part, is all about. The other thing this is all about is at some point, this YouTube channel started featuring the actions of the Department of Workforce Development. They did not like their actions to be, as Matt White will later say, uh, they don't want to be on network news. They want to be off the network, behind the scenes, making important and vital decisions about people's lives, but not with any scrutiny on their own selves. Well, okay. So what happens next? There's a hearing uh, accomplished at great cost, frankly, um, in person for Joanna Stolar. the second hearing. The first one, some might say, was a complete sham. And the second one, it turns out, was accepted after that hearing that some might say was a complete sham. The another uh, administrative law judge took up the mantle and said, "Hey, just give him to me. Give me the bully. I eat people like him for lunch." Well, that the person who supposedly um, could eat people for lunch refused to be videotaped, and among other things, couldn't provide adequate reasons, and was just generally having problems eating um, a certain somebody for lunch. Proved indigestible, like so much buckthorn. It's really a shame. So ultimately, when confronted with the fact that members of the public were going to attend the hearing and plan to videotape that hearing, that judge contacted her superiors, who, I think this is pretty clear, at least had others contact the Capitol Police Department to have the police there, ostensibly to keep the peace, but really for the purpose of preventing recording. And to accomplish that, uh, it was necessary to discuss the fact that one of the lawyers for one of the parties has a YouTube channel. And one of the officers later divulges that he is well aware of this YouTube channel and ostensibly the need to shut it down or not allow it to record what happens. This, of course, spectacularly backfires, but we'll see what happens. So the hearing goes forth. Now, remember, the entire purpose of the hearing is so that the administrative law judge or hearing examiner can show that she can eat the bully attorney for breakfast, not to hear a Wisconsin Fair Employment claim. So then what happens? And oh, by the way, everything that I'm talking about, if I haven't made it very clear, is allegation. There is public records, but to the extent that I'm apprising any government official of any motive, um, so far these are allegations. The judge conducts this sham hearing, really in with the police, um, and in a completely hostile manner towards uh, the plaintiff and her attorney. The attorneys for the Department of Justice feed into the hostility and bias exhibited by the examiner put there for the purpose of you know, getting the bully attorney, allegedly a bullied attorney. Yeah, bullied is probably more accurate than bullied. But hey, and what was the crime, by the way? What was it that the attorney was doing that was bullying? Was asking the Department of Workforce Development to follow the law. That much like scrutiny um, to bureaucrats is apparently is bullying. So okay, then we have this hearing, and the judge goes into a meeting with. Sorry, let me back up 1 second. During the course of the hearing, it becomes clear that there, or at least that there, let's put it another way. During the course of the hearing, facts go onto the record that upon which one of the attorneys alleges misconduct from the other attorneys. When the attorney makes the allegation of misconduct, the attorney upon which the allegation is made calls 911, and the police come and tell the attorney who made the allegation to tone down his advocacy for his client. The judge, we know her as the hot mic judge, goes into a meeting immediately after those discussions with one of her supervisors, Matt White, and has a discussion with Matt White and another hearing examiner in which they discuss their personal bias and hopes that the attorney that made the accusation will be arrested. Because as we all know, it's really in Wisconsin, it's the person who makes the allegation of misconduct that's not being nice. That's the problem. And not potentially the person committing the misconduct. So, throughout the course of that day, Mr. White and Miss Selsor, the supervisors, discuss among themselves what to do. One of the things that they determine what to do is to shut the hearing down at 4:30. They discuss this with the judge during the hearing. The judge describes this as bothering her and distracting her from the hearing. The judge also divulges during the hearing that she got this instruction, and the attorney who made the allegation of misconduct demands to know from the judge where she got the instruction from. After a significant amount of being asked and refusing to answer, the judge straight out refuses to answer any question about where she received the instruction from, and then denied receiving the instruction, and at some point stated that the Capitol Police were the origins of that instruction. The attorney who made the misconduct allegation went out of the room, spoke with a sergeant of the Capitol Police who informed him that that was not the case, that in fact it was the judge and not the police that were ending the hearing, that was ending the hearing. The attorney returned to the hearing, put that fact on the record, and the judge continued to refuse to identify who was controlling the end of the hearing. The attorney left the hearing and made a significant number of public records requests, none of which ever disclosed the communications we're going to get into shortly. They never disclosed whether or not that Maria Selsor and Matt White were not only making decisions about the case while it was going on, but were listening in on the hearing as it was going on and debating whether or not to reveal Matt White as or they decide not to, don't worry, as the origin of the order to end the hearing. The attorney makes demands after this, once the hot mic hearing is revealed, recording is revealed, makes demands to the same supervisors that because of their apparent bias that they no longer participate in their cases. Well, the supervisors refuse, and Mr. White is explicit that there is no legal way to remove his supervision from equal rights cases. While this is going on and the police and the 911 call, the ultimate supervisor of the Equal Rights Division, Ramona Natera, is not in her office. She is remote. While this is concerning to Mr. White and Miss Selsor, because Mr. White and Miss Selsor told her that there was going to be a problem and that she needed to come in. Mr. White discusses with another colleague of his that Miss Director Celso is not in the office. And he uses, frankly, what I would say is passive aggressive language about how she is not there and he wishes that she would be there. Um, there are other communications that indicate that one of the subjects that they discussed at this meeting in which Ramona Natera was told that she needed to be there was the presupposition that the attorney who made the allegation of misconduct would cause a problem. Now, let's not keep in mind here that the judge who took the case for the purpose of handling that attorney invited the police there. Let's leave that aside for all intents and purposes. The Mr. White has a discussion with his colleague about how he wishes Ramona Natera was there, and the colleague urges him to allow Ramona Natera to fail, and that this is a true and justifiable complaint. I may be paraphrasing there, but that one presumes that that's opposed to all of the illegitimate complaints that they had against Ramona Natera. Matt White and Maria Seltzer both opine that the situation is ridiculous. Matt White specifically tells the legal counsel and the deputy superintendent, the deputy secretary, that Director Natera or Administrator Natera is not physically in the office. One just pauses for one moment to remember the amount of difficulty and grief that Mr. White and Miss Selsor gave to the attorney and his clients the attorney who made a complaint of misconduct and his clients about remote hearings and what pushback there was about following the law because it would require hearing examiners to appear in person. But the supervisors of the hearing examiners insisted that their supervisor appear in person and used that fact that she was not there when the attorney that everybody knew was a bully and everybody knew was going to cause a problem came and fulfilled their expectations, or so they allege. Mr. White, this is now into the realm of, I would say, supposition here. And Mr. White and Miss Selsor continue this campaign of undermining Natera, and Natera is removed from her position less than 2 months later, I'm sorry. Natera is part of the response to the hot mic fallout, but the key grievance against Natera was not that she allowed the DWD to be in such disrepute, but that she did not protect Benitez Morgan from the bully attorney. We pause briefly to just go back and remind oneself to the extent of which Benitez Morgan made demonstratively false statements uh, at the hearing. We only mentioned the one regarding the origin of the instruction, which is what was just recently revealed, but there were others as well. No disciplinary action of any kind has happened to um, Celsor, White, or Benitez Morgan. But about 3 weeks ago, the Department of Workforce Development replaced Ramona Natera with Colin Stroud, a Department of Justice attorney. And we'll get in to Mr. Stroud's background and the rest and other videos. And this is not the first time that, let's say, my standing up to what I will say are bullies has led those bullies to use that fact against another set of bullies. And I said it a month ago when I first learned that it happened. I had a frank conversation with Mr. Stroud, and I somewhat believe that I can't help but believe that the fact that these public records have come out now is related to that conversation. But I don't know. But I will say that one more thing. Both Mr. White and Miss Celsor have denied any interference in an active hearing. And it seems, based on the information we have now, that that's no longer supportable, which is a darn shame because, it's bad enough as it is. But for an attorneys to say that it didn't happen, that I think is problematic. It's also frankly problematic that Benitez Morgan refused to indicate that it was Matt White who told her. Finally, and most importantly, all of these actions, all this time, all the emails, all the communications that all of these Department of Workforce Development people have prioritized their time with, and have, which means that they have cast aside what I believe to be their primary duties: enforcing the Fair Employment Acts, the Fair Housing Acts, etc. of the state of Wisconsin. And that hasn't happened here, and it needs to happen. You got to make them do it, but I guess we will. Thanks for sticking with us. We'll keep you informed.